So thanks everybody for coming. I'd like to thank the firm for hosting us. And my name is Gabriella Richmond. I'm a supervising attorney with InMotion. Also in the room we have some other InMotion staff. We have Heidi Anderson over here, who's our Senior Director of Legal Services. Next to her we have Lindsay Baker, who's our pro bono manager. And back there is Maya Frutsky, who is the pro bono coordinator for Free Frank. That's correct, right? You are the, no, you're not. Never mind. She's the pro bono coordinator, but not for Free Frank. I'd like to introduce tonight's speakers. They are here. Chris Ag is the Senior Staff Attorney and Director at South Brooklyn Legal Services for the Mid-Atlantic Pension
Counseling
Project.
I'm not the director. I appreciate the promotion.
He's the guy that we go to. He's our go-to person, a great resource at South Brooklyn Legal Services. Co-presenting with him tonight is Rachel Bronstein, a staff attorney at InMotion. And I hope you enjoyed tonight's presentation. We're very excited about it. The equitable distribution of pensions is one of the most complex issues that we are presented with when it comes to divorces, and we are appreciative of your interest in this, and we hope that you gain a lot of useful information for your cases. Without further ado, here are our presenters.
Hi, everybody. Hi, everybody. Thank you so much for coming. I just wanted to tell you a few things about InMotion for those of you who are not already working with us, and I think many of you are. But InMotion serves indigent women in New York City in matrimonial, family law, and immigration law. We help many, many women with divorce cases, as many as we can in contested divorce cases, and as Gabriella mentioned, the distribution of pension and retirement benefits is a complex issue and often an issue on which we need pro bono attorneys to represent or to help our clients. For many of our clients, a retirement asset or pension is the only or the most significant asset in a contested divorce, and the distribution of those assets and securing a share for our clients can really mean financial freedom for her in the future. So we are appreciative of your work on behalf of our clients and hope that you can get some help with your cases through this presentation. Thanks for being here.
Okay, so my goal here tonight is to try to demystify some of the complexities that surround pensions. Now, if at the end of the evening you find you still have a lot of questions, I'm always happy to talk with you either by email or by phone, and I'll hand out my business cards at the end. Should I put my number up anywhere? We don't have a blackboard.
We don't have that, but it'd be great if you could hand out your...
Yeah, so I'm always happy to talk with anybody. We're going to start just by a little background on the different kinds of retirement plans that are out there. Now, in the pension world, we like to divide the world up into a lot of sort of dyads. So we come up with all sorts of different ways of looking at pensions. The first big division that we talk about is the ERISA versus non-ERISA pension plans. ERISA is the Employee Retirement Income Security Act of 1974. It's a federal statute that was that really brought a lot of regulation to pensions that had not existed before. Prior to ERISA, it was sort of a wild west. There were some internal revenue code provisions. There was some law out there, but for the most part, pension plans were unregulated, except by certainly by the federal law. There was very little federal oversight. And then we have the non-ERISA plans. Now, ERISA plans are private sector pension plans. So if it's offered through a private company, it's going to be covered by ERISA. ERISA itself is the Supreme Court's called it a complex and reticulated statute, which means in part that you'll find ERISA in actually two parts of the United States Code. You'll find it under the Labor Code, 29 USC, as well as the Internal Revenue Code. So you get to look at two places. A lot of strangely enough, a lot of it's sort of redundant, but if you ever really want to dig deep, you'll see some of the distinctions. I promise not to get too dorky with some of the really hyper-technical things tonight. Non-ERISA plans We have a bunch of different kinds. We have the government plans. So if you work for the city, the state, or the federal government, so we have NYSERS as one. That's the New York City Employees Retirement System. TRS is the Teachers Retirement System. We have the state workers are in the New York State and Local Retirement System. Then we have the federal employees. That's the Federal Employee Retirement System, FERS. And then CSRS, that's the Civil Service Retirement System. That's sort of that's for older federal civil servants. We also have things called church plans. If you have someone who works for, say, an archdiocese as a teacher, for example, or even as a janitor, they might be in a church plan, which might have not, which probably is not governed by ERISA. So instead, you might have to look to state law. And then you have some of the certain, I don't know if you'll bump into these too often in your practice, but some of the real golden parachute packages are exempt from ERISA. They're not covered by it. So the executive compensation packages, buyouts, some of the severance packages. There are some pension-like things out there that only the executives receive. Another way that we like to divide the world up is in between the single employer and multi-employer pension plans. With a single, and these are ERISA plans, by the way. So most of what I'm going to be talking about are the ERISA plans, but I will sort of highlight where I'm talking about specifically, something specific to state plans. I don't talk too much about church plans. They don't come up too often. But if they do, you can always give me a call or an email. I'd be happy to talk with you about them. But you'll probably see mostly city employees are a big part of the practice. I think you'll see a lot of those. And you'll also see a lot of the private sector plans. In the private sector, we talk about single employer versus multi-employer plans. Single employer plans, that's where you have a single company, General Motors, for example. And General Motors will set aside a trust fund, and in that trust fund they'll put money aside for their employees based on the number of hours typically worked. The employer is the trustee of the trust fund, which I'm sure you can see immediately there's sort of a conflict of interest because the more the trust pays out, the more the employer is going to have to make up. And the law has recognized that. And allows it for the most part without too many repercussions. The employer is also often the administrator of the plan. So again, there's an inherent conflict there, but it's recognized, but it's allowable. Multi-employer plans, these are a bit more complicated. You'll see this with some of the larger trade unions. 32BJ is one of them. 1199 is a large one. District Council of Carpenters. So the trades unions. And what you have here is you have one central trust fund, and you'll have one. Well, the general structure is you have one union that will negotiate with a lot of little companies out there. And each of the little companies will contribute to the single trust fund. And the trust is actually administered by a board of trustees that is comprised of equal numbers of union trustees and management trustees. So the conflict of interest is abated somewhat in that sense. Yet another way that we divide the world up is the types of retirement plans. This is a big one. This is a big distinction here. Is a defined benefit plan versus defined contribution plan. Now, a defined benefit plan is a type of pension plan that pays out a monthly installment. This is your traditional old-fashioned pension plan. And the reason that we call it a defined benefit plan is because there's a plan document, and in the plan document you will find a formula that defines what your benefit will be. And this will make a bit more sense when we talk about defined contribution plans. I think sort of the contrast makes everything clearer. But you might find a formula that says your pension will be, years of service, say 20 years of service, times your final average salary, say $50,000, times some sort of factor, 1.2%, you might see that, and that calculation will give you an annual benefit, and then that's paid out over 12 installments during the year. Defined benefit plans. So the idea is that at any given point in your career, you can look at the formula and sort of figure out, okay, when I turn 65, I think I'm going to get about $400 a month, something to that extent. You can always kind of figure out what you'll get. These are benefits that are payable for a lifetime in monthly installments, usually. There are always little exceptions, but for the most part, you'll see these lifetime benefits. The risk is always borne by the sponsor. So that means that if there's not enough money in the trust fund to pay out the money to the beneficiaries, the participants and the beneficiaries, then the employer has to make up the shortfall. And you're seeing that a lot nowadays after the stock market collapse. A lot of companies had to make up a lot of the shortfalls. And again, some of the examples of a defined benefit plan include General Motors, 1199, 32BJ, and also public sector plans, because you can look at NYSERS, New York City Employees Retirement System, and you can say, okay, I know that I put in my 20 years, and I know that I'll get a pension equal to such and such amount. Now, in contrast, we have the defined contribution plans. This is your 401k plan, your profit sharing plan. They're also sometimes called individual account plans, and the reason for that is because an individual account is established in the employee's name, and money is put into it, and then the money is invested. And what is defined in the defined contribution plan is how much the employer will put in for you. It might be a certain percentage of your compensation, 4% of your compensation, or it might be a match, some sort of matching thing where if you put in 5% of your own compensation, then the employer will match it. So what's defined is how much does the employer put into it. Usually the employee can make certain contributions as well, sort of to supplement it. Then that money is invested. It could be something very conservative like a CD, or it could be much more risky like stocks. And then what you have is at the end of the day, when you retire, you look to see how much money is in that account, and that's the benefit. You're not guaranteed anything. The risk is borne by the participant. So if the stock market crashes the day before you retire, well, that's too bad. And that's what we saw a lot with, Enron fiasco, that kind of thing. Again, examples include 401k plans, profit sharing plans. The governments also offer these. These are typically voluntary for the government employees. So the New York City has a deferred compensation plan that you might want to look out for. Federal government workers have something called the Thrift Savings Plan. I think that there are variations on that theme. Just want to talk about what some of the plan documents are that you have that you'll have access to, either through a subpoena records or through getting the participant. The participant is the worker. That's sort of a technical term that we use, but the participant's release of information. The plan is going to have a trust agreement. This is a private sector plan. There will be a trust agreement, very thick and wordy and with a lot of whereas clauses and complicated cross-references, and they're often very difficult to read, and they'll have riders and addenda and little scribbles on the margins and all sorts of things like that. And they're not very user-friendly. They're not meant to be. What we will also have that might be more useful is the summary plan description. This is the handbook that's given out to the employees, and it's supposed to be written in a way that the employee can understand. I've been doing this for a number of years, and I still sometimes read summary plan descriptions, and I still can't figure out what they're trying to get across. So they're not. They do tend to be written by lawyers who might have lost their common touch, I think. So that does happen. But the most important thing that you'll find in the summary plan description for most purposes is you'll find the formula. You'll actually find how they calculate the benefit. So you definitely want to get hold of the summary plan description. If there's a collective bargaining agreement involved, that might be helpful. That'll probably tell you something more complicated than you really need to know. It'll tell you how much the contribution rate is, which for a defined benefit plan is way too complicated and dorky, I think, for our purposes. Statutory and regulatory provisions, obviously those aren't really plan documents, but they govern. Again, that's ERISA and the code. The private sector, in the private sector, the public sector pension plans are all governed by retirement and social security law here in New York. Or for the federal employees, that's covered by, I forget which title, but the civil service and the federal employees retirement system is also governed by the code. You can also ask for vesting benefit statements from the pension plan. You can find out how much the participant has accrued as of a certain date, even if that person is still working. So you can find out, okay, if that person were to stop working today, he or she would have a pension worth such and such an amount at the age of 65. So they're vesting statements. The other thing you can ask for is the plan's quadro processing procedures. They'll actually have an outline of what do they do when they receive a quadro. How do they process it? What are they looking for to make sure that it is in fact a qualified domestic relations order? And a lot of plans actually have, as part of their procedures, they've actually come up with their sort of model quadro. So you could always want to get that, because it can be a helpful starting point. This is what the plan believes is a model, and they can't force you to use it, but it's a good starting point, definitely. I did touch briefly on this idea of vesting, which is an important feature, because what it means, vesting is simply put, when does a participant become entitled to the benefits? You usually have to work a certain number of years before you become entitled to your pension. So you can start earning your pension on day one, but you might not become entitled to actually receive it until you, say, put in 5 years. And then you become vested. Now, for your purposes, even if the participant hasn't vested at the time of divorce, all right, let's say they've only worked for 3 years when you're getting your during the marriage, you can still seek equitable distribution of that future pension if that person ultimately does become vested. So if you have someone who's been there for 3 years, you can still get a quadro in place. And it won't become effective until that person's actually gained vested status, say after 2 more years of service, if it's a 5-year schedule. But sometimes you might have opposing counsel say something like, "Oh, well, he's not vested yet." Have you seen that? Yeah. Well, that's great, but you can still proceed. It is still sort of inchoate, but it could become a valuable asset. So certainly, don't let that throw you off. And the SPD is where you'll find the vesting requirements. Under ERISA, what ERISA did primarily, and most importantly for our purposes, is it set these vesting floors. It said, okay, a pension plan can no longer make people work 25, 30 years to become entitled to a pension. That's what was going on beforehand. You had these programs where you really weren't earning anything until you were 65 years old, and you had put in your entire lifetime. So then they would fire you and the day before you reach retirement age, and that was the end of it. What ERISA did was they said, no, we're going to have these floors. We're going to say you cannot make people work more than so many years before they become entitled to a pension. So for defined contribution plans, they're always vested in anything you put in yourself. So of your pre-tax or post-tax dollars, that's your money. You can always get that back, plus the earnings and interest on it. As far as the employer's contribution, they can make you work 3 years before you can get that. So after 3 years of service, you are vested in the employer contributions. For the traditional defined benefit plans, again, those are the ones that pay out a stream of income for life. It's a little more onerous. Nowadays, you have to work at least 5 years under what we call cliff vesting, meaning either you're vested or you're not. It's 100%. And that used to be 10 years as recently as 1999, but nowadays it's only 5 years. Sometimes you'll see a graduated vesting plan where you earn 20% vesting each year until you become fully vested. You see that very rarely, but they do exist. So it's over a 7-year period they're allowed to do that. So you're partially vested in a sort of step system rather than the cliff where you're either all in or all out. The non-ERISA pension plans, the state plans, they all have vesting rules as well, and those are determined by, at least in the city and state, we had this tier system where the longer ago you were higher, the smaller your tier. So you have tier 1 through tier 2, 3, 4, and 5 now, I think. And each tier has its own rules, but right now they're all 5 years as well. They've been sort of keeping track with the private sector. Payability date, when do these things become payable? Normal retirement age under ERISA is age 65. So we're always talking about a 65-year-old retiring. A lot of retirement plans also offer early retirement benefits. They're reduced actuarially, just the way Social Security will do that. And a lot of these pensions will allow you to start collecting as early as age 55. The reduction is quite steep, typically at 40% reduction. But if you're not in good health or you don't want to work any longer, you might want to take that. A lot of pensions also offer a disability pension, meaning that if you become disabled, they will start to pay you something no matter how old you are. Form of payment, how do you receive your pension? As I mentioned before, for a defined benefit plan, it's usually paid out as a lifetime annuity, meaning that you'll get it for the rest of your life, and as we'll talk later, for the rest of the life of your beneficiary. Defined contribution plans are usually paid as a lump sum. That's what you have in your account when you retire or when you leave the employer. You might have $100,000 in there, and then you can either take it out in cash, subject to very steep penalties and tax rules, or you can roll it over into an IRA, or if you're going to a company that also has a defined contribution plan, you might be able to roll it over into that, so you can kind of keep everything together, so you're not just sort of leaving these things all over the place. Okay. Now we're moving on to the issues that occur when participants get married. So I call it tales of love loss and betrayal, because we have all the soap opera elements that you'll see in real life come to play in the pension world. And you thought this was going to be boring, right? So the first thing is survivor benefits. What happens? The couple remains a happily married couple until someone dies. So that's the scenario here. So it's love and loss. So we talk about, and this is primarily ERISA again, so sort of focus on that. We have, under ERISA, we have pre-retirement and post-retirement survivor benefits. Pre-retirement means, back up, that's when the employee spouse passes away while still working, for example. What happens to the pension that person has earned. Post-retirement is when the participant has made it to retirement, retires, and then lives out his or her golden age and then dies. So that's what we're talking about here. Now, for ERISA, under ERISA, we have this default rule that the non-employee spouse, which we call the beneficiary, that's the non-working spouse, is entitled to survivor benefits by law, pre- and post-retirement benefits. So this is due to a 1984 amendment to the law that was championed by Geraldine Ferraro. Now, the only way around this default rule is if the non-employee spouse, the beneficiary, waives that right in writing that's notarized or witnessed by the plan administrator. And the writing itself has to be it's a pretty technical document. It says, I understand what I'm doing. I'm giving up my rights to receive survivor benefits. I know that. This is what I'm doing. I really, really, really want to do this. You might ask yourself, why would you want to do that? Well, it happens sometimes, but oops, sorry, I'm bouncing around. Pre-retirement survivor annuity. This is a survivor benefit that's paid at the date when the participant would have retired. So this is someone who dies at, say, 47 years old, has put in 10 years of work, is married, and then dies. The surviving spouse will then get a pension for the lifetime of the surviving spouse at the age when the participant spouse would have reached 65. Okay, it's not the surviving spouse's 65th birthday; it's the dead spouse's 65th birthday, and it's going to be about 1/2 of what the participant had earned. We call it a qualified joint survivor, pre-retirement survivor annuity, 50% annuity. You'll sometimes see that terminology, 50% benefit. So it's going to be 1/2 of whatever would have been paid to the surviving spouse. I'm sorry, to the participant spouse. Please slow me down if I go too fast. Yes?
Just to clarify, so if they were both 47 and the working husband died, she wouldn't get anything from the time she was 47 to 65.
Right. The question was, if the couple would both, if they were both 47 years old, and then the participant spouse dies, the surviving spouse would have to wait until he or the participant spouse would have been 65. Right. So that could be. I had a case a few years ago where the non-employee spouse was quite a bit older than the working spouse and turned 65, but we had to explain to her that she would have to wait until he would have reached 65. So that's the kind of scenario that you'll have there. So the post-retirement joint survivor, this is where the participant reaches 65 and retires. This is what we call a qualified joint survivor annuity with the 50% survivor benefit. So again, it's 50%, that's what the law requires, that the participant will receive a joint survivor annuity that's pays out $1,000 a month during their joint lives, and then when the participant spouse dies, predeceases, the surviving spouse will receive 1/2 of that, $500, for the rest of his or her life. So this is getting a little technical, but the dollar amount. So if, for example, you're going to see this on, if you get a vesting statement, it'll probably only give you the dollar amount in the terms of a single life annuity, which is payable only for the lifetime of the participant. It'll say, okay, at 65 you'll get a pension of $1,000 a month. Does that mean that under a joint survivor annuity, it would be less than that, however, because what they do is an actuarial adjustment incorporating the fact that they're now paying out over 2 lifetimes. So the 50% joint survivor annuity might be only $900 a month, and then the surviving spouse would get half of that smaller amount. Again, this is really technical, but that's why you'll see these discrepancies. You'll say, well, I thought it was going to be $1,000 a month. Well, no, it's because you're paying out in a joint survivor annuity. And this is why sometimes non-working spouses will waive their rights to a survivor annuity, because you get more now during their lifetimes. So, you might have a reasonable waiver if, say, if the non-working spouse has been diagnosed with a terminal illness, they might waive that right because then more money will be paid out during their joint lives. So you might see that kind of scenario. Okay, so we're about ready to move on to sort of the real heart of this topic. I'm going to be passing it off to Rachel. But we do have a CLE code. For those of you watching at home, if you call in this number, you can receive great prizes, I guess. No, it's the letters R, D, S, U, Q, K. So I guess you have to report that if you want to get CLE credit. So that's again R, D, S, U, Q, K.
Great, so jumping into the distribution of pensions or retirement assets in divorce cases. Pensions are considered marital property under the domestic relations law, the New York State divorce law, DRL 236B. We're going to talk about some of the provisions of that law in a moment. You will hear reference to the case Majauskis, which is the seminal case that in which the New York Court of Appeals determined that pension benefits are considered marital property, and we're going to talk about that in a little more detail in a moment. Importantly, the law changed a few years ago to require, under the domestic relations law, the provision of automatic orders to the defendant's spouse, and which are also applicable to the plaintiff's spouse, that require essentially status quo of the marital estate, of all the property and assets and debt for that matter that comprise the marital estate, what may be divisible or distributable to these parties in a divorce. I just want to read the language from that statute that pertains specifically to pension and retirement benefits. And again, these orders are issued at the beginning of a divorce case. Each party is on notice that they may not in any way dissipate, for our purposes here, retirement benefits, because they may be distributable in a divorce case. So just to read some of this language, it states, neither party shall transfer, encumber, assign, remove, withdraw, or in any way dispose of any tax-deferred funds, stocks, or other assets held in any individual retirement accounts, 401k accounts, profit-sharing plans, KEO accounts, or any other pension or retirement account. And it goes on to say that neither party shall take any loans against or in any way sort of waste those potential marital assets to be divided in the divorce without the consent of the other party in writing or upon further court order, except that any party who is receiving payout has already retired and is receiving the pension benefits or the retirement benefits may continue to receive those payments. So it's sort of a freeze. The picture is frozen once that divorce action is started. And you will talk with clients, I've done it myself, who say, I'm afraid that he's going to liquidate that account or take loans up the wazoo. This requires that neither party shall do such a thing, and it would be a violation of court order to do so. So in divorce cases, there's compulsory financial disclosure, which for our purposes means that parties shall share information about their retirement or pension benefits. This is again pursuant to the domestic relations law, which requires that parties exchange what's called a statement of net worth, which is essentially an assets and liability statement stating, here are my expenses, here is my income, here are my assets, and here are my liabilities, and may include information about retirement accounts. Along with that, the parties are to exchange documents pertaining to assets. Again, pension and retirement benefits being some of those assets. Also worth pointing out here that the trial court rules that govern New York State trial courts are applicable and are a resource that you should read and understand. Specifically in matrimonial cases, the site is New York Code of Rules and Regulations, CRR 202.16. That section, which is available on the New York Court's website, governs matrimonial actions, including the exchange of mandatory financial disclosure in matrimonial actions, and specifically requires parties to share statements immediately preceding and following the date of commencement of the divorce case, including statements pertaining to deferred compensation plans of any type or nature, specifically including pensions, profit sharing plans, 401k plans, etc. So this information is to be front and center in a divorce case. Again, significant for our clients because often pension and retirement benefits are the greatest asset to be divided up in a divorce. So there's a sort of first step concerning marital property or property that is titled to either party, either spouse in a divorce case, that may be considered marital property. And that is the classification of that property by the court as either separate property, either mine or the other spouse's, or marital property, joint property between us. And just to be clear again, of course, I'm using property in the broadest sense here, that it can include pension and retirement benefits, land, cars, furniture. Marital property is to be distributed equitably, which doesn't necessarily mean equally, and we'll talk about that in a little bit. And the parties can agree on how assets, and for that matter debts, can be divided in a divorce. Otherwise, the court will make that determination, the final judgment of divorce. So I mentioned that this Majauskas case, for which you see the site here, is the seminal case decided by the New York Court of Appeals in 1984. And you'll hear this as shorthand in court or with your adversary. We're going to Majauskas the pension. This is the source of the law on this. A couple of quick facts to sort of set the stage. Majauskas, in that case, the plaintiff was the husband, the wife was the defendant. The parties were married in December 1973, and shortly before that, the husband had begun to participate in the retirement plan available to him as an NYPD officer. He had been working for the NYPD a few years earlier, but in 1973, before he married, he began participating in the retirement plan. The date of the commencement of the divorce action was August 1980. So by that time, he'd been working more than 10 years and was a participant in the NYPD plan for more than 10 years. So he was considered vested. So Majauskas itself deals with a divorcing couple with a participant in a vested retirement account. And importantly, the court in that case did two things. One, the court held that retirement benefits are marital property. Again, this is the source of today's distribution of plans on this point, and I want to just read the language, the court's rationale as to why those benefits are considered marital property. The court stated, whether the plan, the retirement plan, is contributory or non-contributory, the employee receives a lesser present compensation plus the contractual right to the future benefits payable under the pension plan. To the extent that those benefits result from employment time after the marriage and before the commencement of a matrimonial action, they are contract rights of value received in lieu of higher compensation, which would have otherwise enhanced either marital assets or the marital standard of living, and therefore are marital property. So with that rationale, the court reached the decision that the husband's retirement benefits were marital property. The other thing that the court did significantly in this case, and Chris is going to speak on this more later in the presentation, is affirmed the formula applied by the trial court used to determine, in this case, the wife's, the non-employee spouse's share of the retirement benefits. And as you see on the slide here, this means that the retirement benefits earned or accrued during the marriage are marital property subject to equitable distribution. It's called the marital portion. and retirement benefits accrued either before the couple was married or after the date of the divorce action, the date of the commencement of the divorce action, belong to the participant alone. And here's just a graphic to make that point cleaner. So in year one, let's say the participant starts employment. Year two, the parties marry. Year three, the divorce action is started, and year four, the participant's spouse retires. The marital portion here then is that portion that accrued between years 2 and 3, date of marriage to date of commencement of the divorce action. Another view of that, you have the length of marriage on the left, the years of the participant spouse's covered employee on the right. Where they meet in the middle is considered the marital portion.
That was just me having fun with the PowerPoint presentation.
I take no credit for that.
Sorry, it's the date of divorce commencement?
Yes.
Finalization.
The date that the divorce commences. So the divorce will commence when the plaintiff's spouse files the summons with notice. That is the golden date. As I mentioned, the domestic relations law governs the distribution of retirement benefits as marital property and other assets as marital property. There's a long list of factors in DRL 236B, which I will not read, except to point out that a couple of examples. The court considers the financial situation of the parties, their income, property, or assets available to them, both during the marriage and when the divorce case has begun, how long of a marriage, and this is often significant, the length of the marriage, because we've seen in many cases, as it states here, frequently but not always, the marital portion of the retirement plan that either the parties agree to this or per a court's determination is 50-50. So if you have a 25-year marriage and the participant spouse has been participating in that retirement plan for much or all of that marriage, you can bet on a split of that asset being 50-50. Again, it's not a legal presumption, but it's frequently the case. Another important factor under the 236B factors here is whether one spouse will lose pension rights upon dissolution of the marriage. So in other words, what is the future of that non-employee spouse? It's another thing that the court considers in determining how the pension benefits will be divided. And of course, the parties can always stipulate or agree to the division of that asset. With regard to the form of payment to the alternate payee or the non-employee spouse, there are a couple of options here. One option is to offset that retirement benefit portion that non-employee spouse is going to get as against other marital property. So for example, if there's a house that's a marital asset or a savings account. If with a defined benefit plan, it would require you to engage an actuary, an expert, to determine what is the present value of those retirement benefits. As Chris discussed, there's a long view of what those benefits will be when the participant spouse, say, reaches 65 years old. But in order to say that today, in this divorce case, either by agreement or by court order, we're going to divide those benefits and offset the retirement benefit share for the non-employee spouse as against another asset, you need to know what the dollar value is today of that defined benefit plan. So it would require engaging an expert to do that actuarial calculation. For a defined contribution plan, a profit sharing 401k plan, the value of the account is the account balance as of the date of the commencement of the divorce action. So it's just like a bank account in that regard. You look at the statement, dated at the time that you needed it to be dated, and that's the value. So if you can ascertain the value, you can offset it against an asset. But in cases where, say, you're representing the non-employee spouse, where your client does not want a lump sum or there's no asset for that lump sum to be offset against, you might instead prepare a domestic relations order, and we'll talk about that, and apply that Majauskas case and the formula that Chris will explain in a few minutes. So Chris mentioned it earlier, and I've just mentioned it again. The court order that governs how those pension or retirement assets benefits will be divided is called a domestic relations order. It's an order issued by the Supreme Court or a family court judge, specifically with regard to the enforcement of support orders, and it's a less frequent issue that we face. More often we're talking about domestic relations orders in Supreme Court, but it's an order directed to the plan administrator. So that order will then stay on file with the pension fund, and when the participant's spouse retires, there'll be an order stating that X portion of these benefits shall be paid to that participant's former spouse per this domestic relations order. And so it, as we say here, directs the payment of benefits directly to the alternate payee or non-employee spouse. Now, ERISA requires qualification of the domestic relations order, and in order to do so, there are statutory or plan requirements. Non-ERISA plans have similar requirements. Generally, it's not considered a qualification of the domestic relations order, but approval or disapproval of that order. Some of the important rules under ERISA for reviewing a domestic relations order state that quadro may not provide to the alternate payee any type or form of benefit or option not otherwise available to the participant under the plan. The quadro may not provide the alternate payee with a joint and survivor annuity with respect to that alternate payee and a subsequent spouse if she remarries, let's say. The quadro may not provide to the alternate payee any increased benefits.
Right. What that means is that you can't have a pension, you can't have a quadro that, say, tells the pension plan to pay the alternate payee more than what the participants already earned. So, a lot of this is real complicated lingo, but pretty straightforward reasoning when you think about it. Yeah.
And finally, the quadro may not pay any benefits that are required to be paid to another alternate payee under another order previously determined to be a quadro. So if the participant had been married and divorced, and that divorce case resulted in a quadro for his first spouse, your client, his second spouse, can't receive any benefits that would otherwise be paid to his first spouse.
Yeah. And there's a very famous case, I forget which circuit it's in, but it involved a gentleman who had been married 8 times. So when he died, he had 8 different women pursuing the money, and they all had quadros. So be on the lookout for these repeat married fellows who who might have their pensions already sort of open for.
So most plans will pre-approve a proposed quadro before it's filed with the court. So what this means in real life is, say that you're representing the non-employee spouse, as often we do. You negotiate a settlement on her behalf, and as part of that settlement, you negotiate that she's going to get a share of his retirement benefits, and you negotiate all the aspects of it. Now you've got a stipulation settlement. You can draft a quadro based on that stipulation of settlement, and you send it to the pension fund for pre-approval before you have the divorce court order it. It is a good idea because it avoids the need to amend an order that might otherwise be rejected by the plan. I mean, as Chris said, many of the plans have a model order which you can follow. You can also engage a consulting company to prepare that quadro for you, but those consulting companies are quite familiar with, for example, what a NYSERS quadro should look like. But many courts actually require that you have that quadro pre-approved so that the court knows that it's signing an order that's going to be acceptable to the plan later. And this is something that Chris and I have talked about, and I've talked about with some other attorneys working with us. There's a potential issue for trouble if the pension plan says to you, well, okay, it's going to take up to a year for us to pre-approve this quadro that you've drafted. And now you have a deadline by which you need to file your final divorce papers with the court. I mean, as I said, best practice is to simultaneously file your final divorce papers and a pre-approved quadro with a letter stating that it's been pre-approved by the pension fund. But if you can't do that, you run a risk for your client that after you file those final divorce papers, now you're waiting for that quadro to be pre-approved before filing it. In that interim, however many months go by, what if there's a change in the participant status? The husband retires and chooses a way, a form in which to get his benefits that doesn't account for your client or doesn't account for the agreement that you made in the divorce case. So there's a potential for some inconsistency there.
Absolutely.
And I mean, I would say, and Chris, tell me if you disagree, that if that happens, and it happened recently with us with the state employee retirement system, but because they have a long wait for pre-approval. But if that happens, I think best practice would be to put a letter to the pension fund stating, just so you know, we filed final divorce papers, we're eagerly awaiting that pre-approval letter that we've asked you for, sort of put them on notice that if there's a change with their participant, it may have some consequences.
I think that's a good idea. I don't know, maybe you might also, I don't know, maybe you have more knowledge about this, but you might want to get an injunction against the participant spouse not to do something like that.
It's interesting.
I don't know if that would work.
I wonder if this is just thinking, I wonder if
Yeah,
the automatic orders the automatic orders, well, I guess once the divorce judgment is final, the
Right.
automatic orders are off the table.
Oh, okay.
So however long it takes you to get the court to sign the final papers, the final divorce papers, you buy a little time, maybe if the automatic orders cover you. But it's an interesting point for post-divorce.
Right.
Can you sort of seek a status quo? Interesting. Yeah.
I just want to interject that sometimes the plan, when put on notice, will in fact sort of put a hold on, on any changes.
Okay.
That's been my experience. I had a case, not too long ago where that happened. So that's something.
Well, that's a good point too.
Yeah.
Yeah, a lot of plans. Most of these plans, their concern is they don't want to pay somebody out and then have someone come
Right.
to them and say, "Oh, you should have been paying me." That's their fear. Generally, if you don't have a quadro on file, and someone comes to them and says, "Okay, I'm ready to retire," well, they haven't been involved in the divorce,
Right.
so they don't really know what's been going on. So they're innocent in that sense. So you have to be careful. That's what I was thinking.
Interesting point.
Yeah.
And just a note here that the federal employee retirement system and the civil service retirement system will not pre-approve DROs.
They won't. They consider them not ripe for adjudication. They have this very strange theory that they're adjudicating, and they will not. It's really annoying. And they take forever to process anything. They're very kind. They'll respond to you. They'll tell you, if you email them asking what's going on, they'll email you back pretty quickly saying, "Yeah, we know." So, but they're very slow, and they will not do a pre-approval. So if you're going to court and you want to file a domestic relations order for CSRS or for FERS, you have to do an attorney affirmation saying, "We can't get this pre-approval letter from these guys," based on experience.
Do they at least provide a model?
They do.
Okay.
Yeah, and very, very thorough models, actually. I mean, the models cover everything. They're probably some of the best models out there, actually, that I've seen, because they cover every contingency possible.
Importantly, a DRO can convey only those rights to which the parties agree or that the court has decided. So there's the potential for malpractice if the attorney fails to include provisions protecting the alternate payee's right to survivor or other benefits. And I wanted to draw your attention to a case on this issue. It's a case of McCoy versus Feynman. It was decided in 2002 by the New York Court of Appeals. And in that case, the plaintiff wife sued her former attorneys, alleging that they negligently failed to secure pre-retirement death benefits for her under her ex-husband's employee benefits plan. the parties reached an open court stipulation, a stipulation orally on the record in court, which then was encompassed in a divorce judgment. And that stipulation stated that the wife should receive 50% of the marital portion of the husband's, quote, pension plan under the Majauskas case, but made no mention of pre-retirement death benefits. And that stipulation, as I said, was later incorporated in a judgment of divorce, which was filed with the court. Later, the wife sued because she wasn't receiving any pre-retirement death benefits, and the court held that that stipulation did not clearly evince the party's intention to allocate those pre-retirement death benefits as marital property, and that the attorneys were negligent. The case, the malpractice case failed for other reasons. The court held that the claim was time barred, but it's an important cautionary tale for attorneys that even if you are able to, through your law firms, hire a consulting firm to actually prepare the DRO, the domestic relations order, it's imperative that you understand the benefits that the participant spouse actually has, and meaning whether that person has a pension, 401k, whatever it is, the types of plans Chris described, and what are other benefits that might be available to that participant and therefore your client under those plans, and that you know that when and if you negotiate a settlement in the case, and because that's the time, and that you're very clear about what you've agreed on.
Yeah, absolutely. I mean, I just sort of want to emphasize, just for the ethics portion of this, that you can do a quadro that awards survivor benefits to the non-employee spouse. So that the quadro can say the alternate payee shall be treated as though they were still married for purposes of survivor benefits. Survivor benefits go only to surviving spouses, but the quadro can say, and you'll still be treated as though you were a surviving spouse. It's a really nice one of these little pretend things that we do here in law. However, if you come to me with a settlement that says, okay, we're going to Majauskas the pension plan, that does not cover, that does not include, by the Court of Appeals has held on many occasions that that language by itself does not encompass survivor benefits. They treat the two separately. They say if you want to have survivor benefits, you have to be explicit about it. So you want to have a settlement agreement that says, we're going to Majauskas the pension plan, and we get survivor benefits. So just be very, very clear on that. Now, I mean, you can bargain that away, obviously, for something else. For your own protection, you might want to keep track of what you gave away for that, so that 10 years later, when the client comes to you and complaining, you can say, well, yeah, that's because you got the house. That's what we gave up for you. You might also, and I mean, again, if you're talking about a relatively short marriage, then maybe survivor benefits aren't really appropriate. It's not something that you have to go through sort of 18B, your GRL 236B factors, and they sort of apply with equal force to the survivor benefit aspect of it. So if you're talking about a relatively short marriage, well, maybe survivor benefits that might not be something that you would win in court, but certainly for a long-term marriage where the parties are approaching retirement age, then survivor benefits are very important. And the failure to get them, there are a number of malpractice cases out there that are published where this sort of thing occurred. So just keep an eye out for it.
And you may find some reluctance from your adversary if you're pushing hard for survivorship benefits, because as Chris pointed out earlier, it will mean an actuarial reduction for the participant spouse's benefits if your client is treated as his surviving spouse at his retirement age.
Right.
So he, his lawyer will say, well, why should my client get more? And again, if you think that you would have a good argument in court if a judge were determining this issue, because under the equitable distribution law, it's been a lengthy marriage, perhaps your client has put off career or education to support the family, or whatever the facts are, then you should push hard for your client to secure that level of benefit for her life.
Absolutely.
God, it's on to you. Let me read
Okay.
another code for those viewing the video. The code is H.
Take a break
Yeah.
now?
Is it?
Yeah,
Yeah.
yeah, we're gonna break.
Okay.
So we'll take 10-minute break?
Sure.
5?
Sounds good.
Okay.
Thanks.
Okay, so I guess we're back. I just wanted to start off this section by giving my phone number and email address, because I was looking for the materials and I didn't see that. My phone number is 718-237-5543. And my email address is cdagg at sbls.org. Feel free to call or email me with any questions, or if you ever have any problems with the pension problem, or I get lonely, so just give me a call. And, be happy to talk with you. I've had the pleasure of working with some of you already, so I hope to continue to do that. We're going to get into some of the nitty-gritty about Quadros now. So I'm going to sort of slow it down a little bit and really spend some time on it. It's not as painful as a root canal, but it's necessary. So let's dig in. So we're talking about calculating the, calculating the AP share. The AP is the alternate payee. It's the non-working spouse. We have the participant and then the alternate payee, and that's what the Quadro language is going to have. They're no longer talking about plaintiff and defendant. We're always talking about participants and alternate payees. But a Quadro can assign a specific dollar amount to the alternate payee. You can have a Quadro that says the alternate payee shall be paid $300 a month. Nice and simple. But what does it? It does not include things like cost of living adjustments, obviously. It's just a flat dollar amount. And you have to be careful again about survivor benefits. It's just not as fun. It's just not as much. It's just not as interesting as using the Majauskas formula. So technically, the defined benefit plan, you can use the Majauskas formula. Defined contribution plans, the domestic relations order can just order the value of the account on the date of commencement of action. So again, you sort of take a snapshot, how much money was in there on the date that the divorce action started, and that's how much you divide in half. Less whatever was brought in before the marriage, right? Again, because we're always talking about separate marital property, so anything you bring in before, and anything put in after date of commencement. So again, you're sort of looking at, okay, what's in there on the date the action started, and then you sort of subtract out whatever was put in before the marriage, and you ignore anything put in after the marriage, after the date of commencement of action. So when you're talking about Majauskas, it's also called the coverture fraction. Coverture is in one of those ancient common law terms that refers to women as chattel of the husband, so it's sort of a nice offensive term, but you will see that sometimes, people talking about coverture fractions. And that's the formula, and we'll talk about the formula. The Majauskas formula, and again, technically this is for your defined benefit plan. And one thing to keep in mind is that what it does is it entitles the alternate payee to the share in the pension as it's ultimately determined. And that's under the case of Olivo v. Olivo. And I'll talk about what that means in just a moment. If you think about Majauskas formula as a fraction, the denominator is the total number of years of service at the time of retirement. And I think this will become more clear as I go along, so don't get too panicky yet, because I know it doesn't make a lot of sense. Here's one nasty formulation of the Majauskas formula. And you'll see it goes on and on and on, and you will see this in some Quadros, and I've done it myself. But what it says is that this order assigns to the alternate payee an amount equal to the actuarial equivalent, and already your eyes are glazing over, I know. whenever you see the words actuarial equivalent, I just know people just start to fall asleep. But it could be, it's 50% of the marital portion of the participant's accrued benefit. As of the participant's benefit commencement date or the alternate payee's benefit commencement date if earlier. That's another thing, pension lawyers love to do that kind of, you'll have the later of the earlier of the two, the following, and then it's just really terrible stuff. But you look at all this, and again, my favorite's always the numerator, of which is the number of months of the participant's participation in the plan, earned during the marriage from the date of marriage to the date of commencement of action, the denominator of which is the total number of months of the participant's participation in the plan as of the earlier of his date of cessation of benefit accruals, or the date that the alternate payee commences her benefits hereunder. You're thinking, oh God. And here's even another one. I think I'll just spare you that. What does all this mean? Is I tried to do a nice little graphic here. So what you do is, here's the Majauskas formula in a sort of a spatial sense. It actually looks better as a mathematical formula, I think. You have a fraction. The numerator are the credits that were earned during the marriage. The denominator, the total credits at retirement. So that's what all this was trying to say. 1199 uses this language here, where they have A and B, and A equals X number of years, and you just want to scream. But this is what it is, nice and simple. So you have, and this goes back to, I wouldn't find it, but this goes back to my little graphics with the years of service. You know, you get married on year 1, and then you start working on year 2, and then you get divorced in year 3, and later on you retire in year 4, and then the marital portion is what's between 2 and 3. This is what this formula is trying to accommodate or incorporate that. So we have credits earned during the marriage. So 1 year, you know, if they're married and he's working during the 1 year they're married, then that's it. Over total years of credit at retirement. So when the person reaches 65, they might have 25 years of service or something like that. You multiply that by whatever the equitable distribution share is, and again, it's usually, not always, 50%. And that will give you the alternate payee's share. So I think, I hope I sort of broke it down so that it's at least conceptually understandable. Does anyone have any questions or, no, what's getting at? Okay, good, so I think I did my job. I mentioned earlier the Olivo case. You can have something called and this is just my own terminology, I've never seen this anywhere before, I just sort of made it up. Something called a frozen quadro. And this is where you have the alternate pay. This is getting really inside. Someone asked me about this stuff once, so I put it in here, but I've since given this presentation and people just kind of stare at me like they're not interested, but I'll try it on you. The alternate payee can receive a share of the pension that accrued as of the date of commencement of the action. The denominator in that case would be the years of service at the time of commencement of action, rather than here total credits at retirement. So if you have it just at total credits at date of commencement of action, so the denominator would be smaller, okay? If you actually want to if you really want to impress your friends, you'll talk about the difference between frozen and Olivo quadros. I really recommend this at parties, if you want to be left alone. But you'll see that it does make a difference. I tried to just show that under the, you make some assumptions here, like if your salary goes up 5% a year, which would be very nice in today's economy, but if it goes up at 5% per year, and then if you have the sort of frozen quadro that's in the middle here, you'd have the alternate payee would get $3,000 and change, whereas under the Olivo quadro, you'll see that it's $3,800. Now, this does become important because sometimes you'll hear the participant spouse saying, well, I don't think she should get anything I earned after the marriage. And in a sense, that's true. She won't. the alternate payee will not. However, the courts have said that what you get is a share of the pension as it's ultimately determined. And why is that? It's because the courts have reasoned that for the alternate pay, for the participant to earn the higher pension, the participant must have worked at a smaller amount, and that was during the time when they were sort of, it's thick and thin, right? We're in it for better and for worse. And so when you extrapolate out, you should also sort of enjoy that, because you were there helping him or her build that career. So that's why it makes a difference. That's why generally the default position is what I call the Alivo Quadro. You'll sometimes see opposing counsel, however, trying to get you to freeze out. So be careful of that. And if you think that's what's going on, give me a call or an email, and I'll take a look at it and make sure that's not, that we're not facing that situation. I don't know how, it is something that comes up with the more sophisticated attorneys, primarily.
Can I just
Please.
Yeah, can I just mention one thing, just to tie back. So in just looking back at the formula, just to be clear, you don't know what the total credits are at retirement. So if you're applying this formula, right, it means that you're not negotiating a settlement where the value of the participant's benefits are offset against another marital asset, or your client's getting a lump sum, because you can't know what his credits will be at retirement because he hasn't retired yet, assuming he's not. So this will remain in this form, right? It will remain in an unknown until he retires. And so your client receives benefits when that event happens.
Absolutely, yeah. And that's the nice thing about using the Majalskis formula, is that you don't have to know anything,
Right.
really.
Right, and were you to negotiate a settlement where the value of these benefits are offset against another asset, you would need an expert to determine actuarially what is his likely life expectancy, your date of retirement, all these things, to figure out what this will amount to in a dollar amount.
Right. And it's by its very nature, it's a speculative endeavor.
Right.
Very speculative. But, they're practiced at it, so it's recognized in the courts. But, let's see, where were we? Okay. I mentioned really early on that sometimes you can get a disability pension. A lot of pension plans offer this. If you have a situation where you have a domestic relations in place and the participant retires on a disability, there is a presumption that the pension is subject to equitable distribution. The participant, however, can overcome that presumption by showing that some part of the disability pension is more in the nature of compensation for personal injury. What I mean by that is that a disability pension is often going to be worth more than what you would get if you had retired with a reduced early pension. So I mentioned earlier that you can sometimes get a age 55 pension. If you become disabled at if you retire normally at age 55, you're going to face a reduction of up to 60% because of the actuarial reduction factors. Now, if you're in that same plan and you become disabled at age 55, your pension might actually be what you would get if you had reached 65. So it's much larger. The participant in that case can say, okay, the difference between the two is actually compensation for personal injury and is not subject to, it's not marital property. Personal injuries are not marital property. They're just not. Am I correct?
Yeah, it's an
Okay.
exception to the statute.
It's an exception. And again, so excuse me. So the participant can overcome that presumption by showing how much of the pension represents compensation for injuries. Now, this is much more important, I think. Domestic relations order and survivor benefits. As we've already mentioned that pre- and post-retirement survivor benefits are subject to equitable distribution. They have to be separately accounted for, though. You have to have an explicit mention in your stipulation explicit mention in the JOD. Because if you come to me with a JOD or a stipulation that just says the pension shall be subject to the Majauskas formula, all I can do with it is give you a simple quadro that says, okay, when this person retires, then the alternate payee gets a share. However, when the participant dies, all bets are off. That's all. So you must have survivor benefits explicitly in your stipulation, or put it into the judgment of divorce if that's where it's going, or both, preferably, frankly. The way survivor benefits and domestic relations work is that the domestic relations order will say when the participant retires, he or she shall designate the alternate payee as the beneficiary. That's just how it works. And you'll get a nice letter back from the pension company saying, well, okay, we understand that, and we're not going to be held liable if they don't do it, but they will have a little red flag in the system saying, okay, this is what's going to happen. So you want to make sure that you get it in there before the person retires. Because obviously once the person retires, the option, so here's the kicker, is that when a person retires and makes an option, selects an option, single life annuity or survivor annuity, after the first check is issued, it becomes irrevocable. So you're not going to be able to undo the damage. So if the person retires with a sort of single life annuity, and then you hand in a quadro, saying, oops, it should have been with the survivor benefit, the pension plan's going to say, sorry, too late, and you're in a lot of trouble. I'm working on a case right now where the divorce was handed down in the early 90s, and it said equitable judgment of divorce granted, equitable distribution shall be determined by a referee. And for some reason it never went to the referee until after he remarried, retired, named his second wife as the beneficiary. So then we come along and we're trying to fix this mess, have a hearing on equitable distribution, and the judge seems to be weighing in our favor. We're hoping that she'll give us something. Well, then what happens? He dies. So now we're really up a creek. I then draft a quadro, and the judge ultimately says, okay, she can have part of the survivor benefit. Okay, so I draft a quadro that gives our client part of the survivor benefit. The pension plan responds saying, no, we don't do that. All right, so what do? Well, we're going to go to court against the pension plan and hopefully convince another judge that the pension plan's wrong as a matter of law. But the moral of the story is you don't want to be in that situation. So, do these things, and as Rachel was saying earlier, try to do it early so that we don't have these sorts of problems, because they do occur, people pass on, usually at the most inconvenient and rudest moments possible. I mean, this gentleman really had no, he really just did not look out for our client's interest when he decided to pass away. It was very rude of him. But now we're in this situation. So again, I really just want to caution everyone to be very careful about survivor benefits. It's very important. A little less important are cost of living adjustments. Those are also subject to equitable distribution, so that should be included in your domestic relations order. So your stipulation can say, the Majauskas share plus cost of living adjustments. That's always nice. Okay. Now this is really technical stuff, but it's another way that we divide everything up in the pension world. I just realized that when I'm doing this, I'm not like pointing at anything.
No.
I don't have a pointer, so. Okay, there are two types, just as there are two types of pension plans in very many, defined benefit, defined contribution, ERISA, non-ERISA. There are two different kinds of domestic relations orders. There's the shared interest and there's the separate interest. Okay. Now, a shared interest is sort of a carve-out. It's the idea that when the pension plan has a domestic relations order saying, okay, the participant has earned a pension of $1,000 and it's to be split 50-50. Very simple. You share the $1,000 check. The benefits are paid out only when the participant retires. So the alternate payee has to sort of sit back and wait until the participant finally gets around to it. And yeah, I've seen spouses be sort of spiteful and continue to work just to avoid having this happen. You know, they'll work on into their 80s because, by gosh, they're not going to let their lousy ex get any part of their pension. Spite is a very highly underrated motivating factor in life, I've learned in my practice, but people do a lot. The alternate payee is entitled to survivor benefits to the extent that the participant designated the alternate payee as survivor. And again, that's something that hopefully was in the stipulation in JOD, and it was now put into the Domestic Relations Order. DRO says that at retirement, the participant shall select option, this particular option, and shall designate the alternate payee as the survivor. Now, you're going to find shared interest. You'll find this in ERISA plans. You'll also find out that this is the only kind of quadro that's available for the public sector plans for some reason. And they don't allow what we call the separate interest quadros, which I'll explain in just a minute. Any question on that? Now, a separate interest is a bit more complicated. What it does is it treats the alternate payee as a participant in her own right. So if you have a separate interest quadro, it'll allow the alternate payee to start collecting benefits at the earliest age the participant could start collecting benefits. Typically an early reduced pension, say 55. And that's even if the participant is still working. Okay. What the alternate payee will get is a single life annuity for her own lifetime. So that's kind of nice. You don't really have to worry too much about survivor benefits in that sense, because the alternate payee goes to the pension plan and says, okay, the participant is now 55 years old, I want to start collecting a pension. And they'll say, okay, here's what we're going to pay you for the rest of your life. So it's independent of the participant. And the alternate payee's benefits are calculated based on her own life expectancy, or his own life expectancy. And this is where it's, the participant the alternate payee can't say, oh, and by the way, can I now name my new spouse as a beneficiary? That's where some of that earlier language came in about what a quadro cannot do. A quadro cannot say that the alternate payee can now sort of keep this thing going on for another generation down the line. So it stops. I mean, quadros can't kind of perpetuate the pension payment forever, only for the alternate. So their pensions are really meant only for for workers and their spouses. You'll sometimes hear, well, what about the kids? They're not really meant for the children. The children should be on their own by then, I think, is the thinking behind all this. And ERISA pension law is a very paternalistic body of law, and they're always talking about, okay, we're going to look out for the worker and the worker's spouses. But they kind of said, well, we don't really care too much about the kids. It never really got that far. So you don't really have benefits going to children or to... Now, a separate interest quadro is not available if the participant is already retired. So if you have a situation where the couple is retired, the participant retires and then they get a divorce, and that happens. People get, they're home all day alone now for the first time in 45 years, and they sort of realize they've grown apart and they really can't stand each other, and it's just not all that great. So they get and the kids have grown, so they're sick of each other, so they get a divorce. You're not going to be able to get a separate interest quadro in that situation, because again, when the participant retired, everything was sort of frozen. The option that he or she selected became irrevocable. So you can't really change things up at this point. When to file a quadro, this we've talked about on ad nauseum by now. File it as soon as possible. This is really important because for a couple of things. When you finally get a signed DRO from the judge, If you file it with your pension plan, the ERISA pension plan, what they will do is they will say, okay, we're going to take a look at this thing and make sure it's qualified. By the way, that might take up to 18 months, which is really too long, but sometimes you'll see that happen. During that time, however, they're supposed to kind of come with a guesstimate and say, well, we think this will give the alternate payee so much money. We're going to put that money aside, sort of in escrow. And ultimately, when we do qualify this, then we'll pay the alternate payee that whole lump sum. In the meantime, of course, you're not paying bills, and so it's not that great, but you want to do it as soon as possible. There is a 6-year statute of limitations that applies to filing quadros. So that starts to run when the participant reaches pay status. So if you have a divorce in year 1, and in year 10, he retires, you have until year 16 to file the quadro under the statute of limitations. Late filing, however, can lead to all sorts of potential problems and potential attorney malpractice. I put in parentheses there, just to be careful. So if you have a situation where you have a judgment of divorce and you don't file the quadro right away, what if the participant dies? Well, that was the case I mentioned. We had this situation where, all sorts of things happen. People get remarried, they retire, and then they die. And so if the death of the participant might stop all benefits, especially if you don't have survivor benefits in the quadro, then you're really in trouble, because then everything stops. The pension plan is saying, well, look, he retired and selected a single life annuity, which is perfectly legal because he was not married at the time of the retirement. He had been divorced. And there was no quadro in place saying anything to the contrary. So that's it. All benefits stopped. There's really nothing you can do about it at that point. The participant might still be alive, but might have retired and have selected somebody else as the beneficiary. The new wife is now the surviving spouse for purposes of benefits. Well, okay, you can get something during the rest of the participant's lifetime, but if he predeceases, then you're cut out. And that's what happened in that case I mentioned earlier. The retirement of the participant also is going to preclude a separate interest quadro, which might be kind of nice. If you want a separate interest quadro, then you're cut out of that. So again, timing is very important in these cases. So don't go by the 6-year statute of limitations and hope you can get away with something there. It's just really important to do this as quickly as possible. And as mentioned earlier, so the best practice is to file the JOD along with the quadro when you're asking for the judge to sign everything. That's not always possible because the pension plan is going to take its time doing a pre-review, but particularly, the New York State and local retirement system takes about a year, but New York City employees retirement system takes about 6 weeks. They're pretty quick, all things considered, so you can get these things done pretty quickly. So there's not too much, there's really no reason to delay, and every reason to move quickly. When you are talking about retirement benefits with opposing counsel, I've sort of come up with it's in the materials here. I have pages 25 to 35, sort of a checklist that might be helpful of just all the information that you should try to gather that someone who's going to draft a quadro for you is going to need to know. Obviously, some of it's pretty simple. The participant and the alternate payees, you want to have their names, addresses, social security numbers, and birthdays. Marital information, you're going to need to know the day they were married, the date of commencement of divorce. Those are the two sort of key dates. If there's a separation agreement, you need to know that because that's going to take the place as the asset cutoff date. If you have a separation agreement, DRL 236 says that becomes the cutoff date, not the divorce action. So that could be years before, right? And really make a big difference. Employment information. If you're still trying to find out what pension plans are out there, what kind of assets are out there, if you're not really too sure that the other side is being fully disclosing everything, one way to find out if there's a pension plan is to find out, okay, well, where did the guy work? He might not even know if he has a pension, but it's easier to know, okay, well, where did that person work? And then you can sort of figure out, okay, I know that the person worked for this company and for that company, so those are the two companies to contact to see if they have pension plans. And then I have, the plans information, and the plan documents that you want to obtain, summary plan description, quadro processing procedures, any models. Some of this is just more technical. I don't think you need to worry about it as much as the preparer would want to know. So, benefit information, the number of months of service, total months of credited service if that's already known. Is there an earlier domestic relations order in place? If it's sort of a race to the courthouse kind of situation, or if there's already one because there's a previous marriage or 2 or 3 previous marriages, then that might be something to be aware of. Protecting the non-employee spouse's rights. Is a stay necessary? Well, there's an automatic stay nowadays, so that's not as necessary as it used to be. Method of distribution, if there's a lump sum option, is that what you were talking about? Or are you going to do an equitable distribution through Majauskas? Survivor rights, we talked about that. Timing issues. Again, this is part of the checklist. I think if you have any questions about it, you can certainly give me a call. But I think I tried to make it sort of self-explanatory. Adjustment to benefits. Again, are you going to include cost of living adjustments? These are just to make sure that you covered your bases here. Reductions, optional form of benefits. Okay. When the participant is if the participant is directed to select an option that will provide for a survivor of annuity, as I mentioned long ago, the joint annuity will be reduced. Okay, it's not going to be the same amount that the maximum single life annuity will be. Well, what do you do about that cost involved? You can actually share it or allocate it singly to one party or the other. So you can have a qualified domestic relations order that says that the participant shall absorb the entire cost of any option selected, or the alternate payee shall absorb the entire cost, or the parties will both share the cost. So you can do things like that where because of who sort of absorbs the loss. Now, if the participant is going to be allowed to select someone else for survivor benefits, then I think it makes more sense for the participant to absorb the loss. If you have a situation where the participant is going to name your client as the survivor, you probably have I think the other side has a pretty fair argument to make that your client should sort of take the smaller portion because of the reduction. Sort of makes sense. She's going to get the survivor benefit out of the deal, so maybe she should sort of take that hit.
Can I just ask you to
Yeah.
clarify that? So your
Yes.
example earlier was on the participant's single life annuity, he'd be entitled to $1,000 a month. If a joint survivor annuity is chosen, then there'd be a $900
Right.
benefit, actuarially reduced. And if they split that 50-50, before 50-50. So in your discussion of absorbing the loss, so what would that mean in terms of those numbers?
Okay, well, what do you do about that $100? Who has to sort of absorb it? You can assign it to one party or the other.
Vis-a-vis those benefits or some other asset, you mean?
In the quadro.
Okay, but what does that mean in concrete terms then?
Well, that
Who's getting what and?
right, you can have it so that the alternate payee's share is calculated based on the reduced amount.
Okay,
Okay.
okay.
Whereas so more, so she will get a smaller amount because of the cost involved.
Got it.
Does that make sense?
Yes.
Okay.
Thank you.
This is another big, this is a more important part. Well, this you'll see a lot. You'll see loans. A lot of pension plans will offer loans where you can take money out, especially the city and state plans. You can take loans out. And when you take a loan out, if the loan is outstanding at the time of retirement, your pension's reduced to make up for the fact that you've taken money out. Who absorbs that cost again? So you can have a quadro that specifies that if there's an outstanding loan, then the participant has to eat the loss. Again, there might be situations where that, if the loan was taken out for something that the two of them benefited from, home improvement project or sending their children to college or something maybe, then maybe it's more fair to have both parties absorb the loss. But I've seen situations where it was more like he took the money out to buy, the red Corvette for the bimbo girlfriend, that kind of thing. Then obviously he should, have to pay for it. Withdrawals of employee contributions. This is more significant with the public retirement systems. They're funded partially by employee contributions. And if the party has the right to just withdraw those contributions and forfeit the right to have an actual pension, what do you do in that situation if that person does it? And again, it's probably not the smartest thing to do, because you're withdrawing only a few $100,000 and you're giving up the right to a lifetime pension. But again, people act out of spite, and they might do this. Well, you might want to have your quadro cover that as well, where it says, okay, if the participant does that, then the ultimate payee gets a portion of that withdrawal. And so again, that's something I usually have in my quadros when that's a factor, when that's a possible option. Taxes. When you have a quadro, the pension plan will send 2 separate checks to each party. That means there's no money passing through one party to the other, which is nice for the participant's standpoint because there won't be any taxes. You're not being taxed on the full dollar amount. You're being taxed only on what you receive. So there is that. That's actually something that's a good, so participants don't mind having quadros in place for that reason. Of course, the primary benefit of having a quadro is that the pension plan is directly paying your client. You don't have to. It's not like alimony where you're always squabbling over getting the check because the money's coming straight from the pension plan to the ultimate payee. There's none of that enforcement problem that is inherent to having the other side pay.
Can I just make a note about discovery? So this checklist, which is incredibly valuable to us, a lot of this information can be obtained through general civil discovery tools. So a subpoena to the pension fund. If the other option doesn't work, which I usually like to try first, which is ask opposing counsel if his or her client will sign a release authorizing the pension fund to provide you with information about his benefits. So if he won't sign the release for whatever reason, you can subpoena the pension fund and get a lot of the information about his years of contribution, his years of service, whatever it is. And as I said, there's mandatory disclosure in divorce actions, and so you hope to know up front if he's a participant, but if he's not, you should certainly find out who he is or was working for, and you can subpoena the employer or former employer also to find out information about his pay and his retirement benefits.
Yes, absolutely. And I have a sample release in the materials
Great.
here, as well as the checklist that we just skimmed through. There's also sample settlement language. In fact, the bulk of the materials are different versions of settlements. So here are a couple. These, as you can see, they're not that long, but this is what you would go to your quadro preparer with, and it would just say the employee spouse's 401k shall be divided 50-50 as to the marital portion. That covers it. Any loans taken against the value of the account balance shall be held against the employee spouse. So that means that the employee is going to be responsible for repaying any loans, or if there are any outstanding loans at the time of the distribution, they're counted against the employee spouse, not against the alternate payee. That's enough for a quadro, for a defined contribution plan. Defined contribution plans, they're just not as much fun because you don't really talk about survivor benefits and things like that. It's just money. Now, for a defined benefit plan, we have one that says the marital portion shall be divided 50-50 and paid as a 50% joint survivor annuity. So that's great. See, that's all it takes. Payments shall commence as of the date of the employee spouse's retirement, and the non-employee spouse, the alternate payee, shall be the designated beneficiary of the survivor annuity and any other death benefits. So that covers all your bases there. That's all you need to do. And that'll get you a survivor benefit in your quadro. Here's one for the New York State and local retirement system. If you have a situation where the participant has already retired, let's say the parties are sort of separated informally, they're living apart, this is pretty typical, I think. So you have the parties are separate, there's no separation agreement, they're just separate. They get the divorce, and there's been no real alimony payments or something. He's been receiving his pension during the entire process. You're not going to be able to get a retroactive payment in the traditional sense because the pension plan that did not have a quadro on file until just now. All right, so they've been innocent. All right, they've been paying him directly the full amount. Now you have a quadro in place, and it says that she's entitled to a share of whatever he's been getting. You can also sort of catch up. You can say, well, for the past 3 years now, he's been receiving a pension that he hasn't been sharing with her. What do you do about that? You can have retroactive payments. Typically what I do is it's a payment that's 1/2 of whatever she would get. So if she's supposed to get $100, she'll get another $50 for twice as long as he's been collecting. And then, so it's sort of you sort of make it up over time kind of thing. It's not as nice as a big fat retroactive pension, but retroactive benefit, but you're not going to get that. But it is a way of doing a catch-up in a sense. So that's what this is here. I've slipped them into into quadros, even though it hasn't been in the stipulation. And I think they've gotten by the other side. But it's always nicer if you come to me with a nice stipulation saying that there won't be any fight about this sort of thing. Oops, that's it. Just wanted to say about the one last thing about the separate versus shared interest quadros. If you come to me with just a real basic, we're going to Majouskas the pension plan and there's no survivor benefits, I'll certainly try to do a separate interest because then you have this sort of lifetime annuity payments. But sometimes the courts are a little reluctant to do that, so I just wanted to. So you can also have it's in the samples here. You'll see some other samples where it says the quadro shall be a separate interest quadro. So you can again, there are different ways. I've seen sort of settlements that really are sort of like the entire kitchen sink is tossed in there and they spell out everything in detail, which is great for me, but it's time consuming and. I think sometimes the thinking is that you don't want to do that for strategic reasons, right? You're nodding. Right. So if you wanted to explain why you might not want to do that.
Hard to come up with an example, but I've certainly been in this situation. Although I have to say, on balance, I'm more interested in spelling out what is going to happen, because I think that it puts everyone on the same footing, which is important because these are important benefits. I wanted to ask a question. I hope this is going to be clear. If a quadro says that the alternate payee shall receive benefits at the earliest date that the participant could receive benefits, does that in itself make it a separate interest quadro? No.
No, it does.
It does?
It does.
In itself?
In
Okay.
itself.
Okay.
Yeah. Well, that's one of the elements of a separate
Yeah.
interest quadro, I'll say.
Okay.
I'll put it that way. That's one of the features. But if you see that kind of language in your quadro, then that's probably what you have. Yeah.
Okay. That's helpful.
Okay.
Yeah. Who has questions for
Any
us?
questions? Yes?
I have a question. What happens when everybody meant to put in the survivor language and they didn't? And then it gets filed with the court and the pension plan. Is there any way to fix that once it's happened?
Okay, what happens if
Assuming everybody's still alive.
everybody's still alive, they meant to put in the survivor language, but they didn't?
Right.
You can still, I mean, you can do an amended quadro in that situation because the parties are still alive. And if that's what the parties are intended to do, then I think that's what you should do.
What if your client thought that's what was going to happen, the other client did not?
Okay, what if there's a difference of
Right.
opinion?
Right.
Then you might have to go back to court and, fight.
Yeah. Yeah.
Yeah.
Are those usually successful or not?
I think I mean, if you have a long-term marriage, you're more likely to get survivor benefits, long-term, and then also it sort of implies that the parties are closer to retirement. There's less chance to go out and earn your own pension. Sort of the usual equitable factors
Right.
that the courts will take into account.
Well, I wanted to point out one other overlooked issue, which was incorporated in what Chris is talking about in terms of supplements. But a lot of times the adverse party in our cases, let's say, is a police officer, and there's an important benefit. The variable supplement fund benefit is, and correct me if I'm wrong on this, Chris, but I understand it to be a yearly supplemental benefit, and I think it's $12,000.
I think so.
If you've joined the police force after 1989 or something like that. And so it's an extra $12,000 that participant is entitled to. The courts have held, as far as I understand, that that benefit need not be specifically referred to in a stipulation of settlement as it's incorporated within the other retirement benefits. But for best practice, I would certainly suggest that you specify that your client is entitled to a Majaska's share, if that's how you're proceeding, of, as Chris stated, the cost of living adjustments, and if the adverse party is a police officer, the variable supplement fund, because it's a big benefit to your client.
Huge benefit, yeah.
Yeah. So again, this information will come to you in the documents that you get in response to subpoenas or other discovery requests or authorizations, and a lot of this is available online. If you want to understand more about the benefits available to NYPD officers, you can hop on the benefits website of the police, I forget what the URL is, and find out a lot of information. And I think its aim is to be written in lay terms,
Yeah.
so that its participants, the fund's participants, can understand, and maybe you too, if this is a new issue for you, hopefully.
Yes, question?
I was just gonna ask, what sort of things do you think about when deciding whether to do a quadro or to maybe get some sort of lump sum or trade? I mean, I know it depends on the case, and some big things, say the wife once, whether she needs money now and whether she needs money later, but what else kind of goes into that calculation?
Okay. Just for the camera here, the question is, what sort of thoughts go into whether you want to have a quadro or do a lump sum payment? Is that a fair shorthand for it? One is, well, the pension plan itself probably does not offer a lump sum option. Most of them do not. So what you're looking for is, if you have a present value of your pension for $250,000, you're not going to get $250,000 cash. So having that present value is of use only if you have another $250,000 sitting next to it where that you can cash out, which most people don't have. I mean, unless you might be a house, is really the only asset that's going to compare for most of our clients. So for the most part, present values aren't even all that valuable because there's really no other asset to compare it with, and there's no cash to sort of purchase, buy out the other party. But if you do have that sort of luxury, the pension is always sort of, having cash in hand might be worth more just because it's cash in hand right now. You might never collect a pension. That might not be payable for another 20 years, depending on the age of the parties. So, you might think, well, that's a long way off. And you can certainly, take the cash if you are able to sort of cash one side out. You could take that cash and invest it theoretically, and maybe do better if you're so inclined, or maybe purchase a house of your own. You might think that's a better investment.
And just for example, we have a case where the client is finishing school and retirement will likely be many, many years away or will be many, many years away for the participant spouse. And so one idea is to negotiate a Majauskas, or negotiate a percentage. Remember, the 50% or something like that. This is a fairly short 5 to 7 year marriage. So negotiate a percentage as against a present value of his retirement benefits that he might actually be able to pay out of pocket now so that she can finish school. So that's the idea. Again, if there's some exigent circumstance for your client, it may make some sense.
Yeah.
Rachel, I just want to talk about getting a divorce financial expert to help you if you're trying to weigh these options.
Absolutely. So a resource that we have available to attorneys working with us on in-motion cases is we've got some financial planning firms, financial advising firms who are willing to offer their services pro bono to us to evaluate those options for the client. So here's what it will look like if you take a lump sum amount, 30% of those benefits now, and here's the way it'll affect your other needs and bills and so forth, or debt that you may have incurred, and here's what it will look like if you wait until he retires. And that can be extremely valuable advice for real world scenarios for what is going to make sense for your client. Many clients, I have to say, many of our clients are not financially literate, like many people out there in the world. And even the wonderful news that she might get $20,000 in a lump sum, it may be difficult to sort of conceptualize how that can affect other things going on in her life and what the best use of that money. And I say this without being patronizing about it. It's just a reality that many of us don't financially plan well. So InMotion has wonderful firms that are working with us and available to our attorneys to help you, even before you get to the settlement table, decide what option makes financial sense for your client. And you should certainly talk to us about that if it's an option, if it's an issue in your case. Any other questions, thoughts?
Do you have any material on the public sector retirement plans? I briefly saw a couple of things in here, but because it's a non-ERISA situation.
Right. What kind of materials?
I'm just reading materials.
Oh, reading materials? Their websites tend to be very good, actually. Yeah, you'll find their summary plan descriptions online. This is for the public sector pension plans. If you go to their websites, and they're all pretty standard, NYSERS.gov or something like that. But if you Google them, you can get all their summary plan descriptions online. There's no firewall or anything either, last time I checked.
Yeah.
So they're actually quite handy. More so than the private sector is still sort of laggard for the most part. Some of them have them online, but most of them don't seem to. But for the public sector, you can get their summary plan descriptions right online, and model quadros online, all sorts of forms and brochures for specific instances. I know NYSERS has just tons of brochures on every topic that you can imagine. Is that helpful? Okay, good. Okay, well, I think, thank you very much for
Thank you.
coming. I hope this was helpful. Like I said, please feel free to call or email, and I'd be happy to talk with you. So, thank you.
Thank you.